I'm Ben Meiselas from the MeidasTouch Network, and this is a breaking news alert. The United States Supreme Court, in a 7-2 decision, granted the Department of Justice's request for a stay of the federal Texas judge, the Trump appointee Judge Kaczmarek's decision, which essentially banned mifepristone and rejected the FDA's approval in 2000 and all of its subsequent approvals. The Fifth Circuit Court of Appeals, reviewing Judge Kaczmarek's order, ultimately granted the Department of Justice's stay as it relates to the 2000 FDA approval, but not the 2016 and later approvals, which extended access to mifepristone. But right now, the United States Supreme Court stayed all but the Fifth Circuit did and what Judge Kaczmarek, the Trump appointee, did, and preserved the status quo of the approvals of mifepristone from 2000, 2016, and thereafter. And so this means that mifepristone remains available, and it will remain available pending a ruling by the Court of Appeals in the Fifth Circuit Court of Appeals, which will now conduct full briefing, not on an emergency basis, through a normal briefing schedule. It may be slightly expedited, but through a normal briefing schedule. And then ultimately, the United States Supreme Court can then determine to hear however the Fifth Circuit Court of Appeals ultimately rules after full and complete briefing, whether or not the United States Supreme Court will take certiorari and hear full oral argument. So this means, though, for a not so short period of time, for a not so insignificant period of time at least, mifepristone will remain available, which is a positive development, of course, and it resolves the conflicts that were now created between its approval which was further affirmed by a Washington state court judge, versus what the Northern District of Texas federal court judge Kaczmarek, the Trump appointee, ruled. Here, let's just pull up this order. You see it right here, Supreme Court of the United States, and it says Danko Laboratories LLC versus Alliance for Hippocratic Medicine et al., an application for stay. And then it has the other case, Food and Drug Administration et al. V. Alliance for Hippocratic Medicine et al. And the court says, the application for stays presented to Justice Alito and by him referred to the court are granted. The April 7th, 2023 order of the United States District Court for the Northern District of Texas, case number 222CV223, is stayed pending disposition of the appeal in the United States Court of Appeals for the Fifth Circuit and disposition of a petition for a writ of certiorari, if such a writ is timely sought. Should certiorari be denied, this stay shall be terminated automatically. In the event certiorari is granted, the stay shall terminate upon the sending down of the judgment of this court. And then you see below, Justice Thomas would deny the application for stay. So Justice Thomas is dissenting to this. By the way, the fact that Justice Thomas, after him being exposed as going on these $1 million lavish trips with a Republican donor, the fact that you even see his name dissenting here and his name in this opinion is absolutely pathetic. And then you have Justice Alito dissenting from the grant of application for stay. So another dissent by Justice Alito. And by the way, Justice Alito was the one who wrote the Dobbs decision overturning Roe v. Wade, and Alito cited like 18th century men who believed women were engaged in witchcraft and should burn on the stake. That was one of Alito's justifications in support of the Dobbs decision, despicably, which overturned Roe v. Wade. I'll go into the dissent in just a moment, but just so you know, like what I just read meant, though, about the application for stays presented to Alito and by him referred to the court are granted. So what the Supreme Court pretty much has been doing on high-profile matters like this is that there's a different Supreme Court justice who oversees the different circuit courts. So, for example, Justice Clarence Thomas oversees what happens in the 11th Circuit Court of Appeals, and Justice Roberts oversees what happens in the D.C. Circuit Court of Appeals in terms of granting emergency applications. And so Justice Alito supervises emergency applications for the Fifth Circuit Court of Appeals and the Third Circuit Court of Appeals. And so what Alito did when an emergency application was made out of the Fifth Circuit Court of Appeals, even though he essentially agreed with the ruling of the Fifth Circuit Court of Appeals, the process and procedure that the Supreme Court justices have been following, regardless of their who appointed them, which administration appointed them, they've all been pretty much granting temporary stays and then referring it to the full court ultimately to make a determination. And they haven't been kind of freelancing and making those emergency determinations on their own. So it seems like they all made a pact to do that across the country. That's why we've had situations, where, in these Trump cases where even, the 11th Circuit Court of Appeals, for example, has, ruled against Donald Trump. But then the enforcement of that has been stayed temporarily, and everybody will be like, well, Justice Clarence Thomas strikes again. And I was like, well, he strikes again in a lot of places, but not there. It is the normal process and procedure for the supervising Supreme Court judge to kind of temporarily stay it and then refer it to the full panel for a decision ultimately of what to happen. So that's what Justice Alito did. Alito gave the temporary stay. Then the request for a more significant stay pending the overall appeal process, that went before the entire United States Supreme Court. And here the United States Supreme Court in the 7-2 decision made the ruling that a more durable stay will take place. And it describes what that more durable stay is. So the stay remains in place until such time as the Fifth Circuit Court of Appeals has the opportunity to hear full briefing from the parties and makes a ruling after the full briefing on the parties. And the Supreme Court says that then, if the Supreme Court grants certiorari after the Fifth Circuit Court of Appeals makes a ruling, meaning if the United States Supreme Court agrees to hear the case after the Fifth Circuit, if it rules differently than what the status quo is right now, if the Fifth Circuit basically rules consistent with what its prior order was, which was to allow the 2000 approval, but not to allow the 2016 and later extensions of the approval of the mifepristone. If the Supreme Court grants certiorari, this stay will continue. If the Supreme Court doesn't grant certiorari, the stay will end. But ultimately, given that they've made this ruling, I think if the Fifth Circuit comes out with the same ruling after a full briefing that they just ruled on, which created a lot of the confusion and problems regarding banning certain applications of mifepristone after 2000, the certiorari grant by the Supreme Court is almost certainly going to be granted, given the 7-2 dynamic that exists right now. Also, what I think was at play here is Justice John Roberts, the Chief Judge, realizing just how problematic the overall Supreme Court decision was in Dobbs, overturning Roe v. Wade. I think he's seen the ramifications about how that completely delegitimized the court. And so here, as it relates to mifepristone, the abortion pill, which has been proven to be safe and its efficacy has never been in question. It's permitted in almost all countries internationally. This would put United States really in a league of its own, an extremist league of its own. I think even Justice John Roberts got the other justices to say, look, the Supreme Court's going to absolutely just lose any shred of credibility it has if we don't do this. So let's basically throw an olive branch here, and for this case, just stay it. Let's see what happens, and let's just delay us having to make a full ruling on this issue. So I think that's the dynamic that happened, why it was a 7-2 ruling. And this is what Justice Alito says in the dissent. I'm not going to read the full dissent for you, but let me give you the key portions. Alito says, in recent cases, this court has been lambasted for staying a district court order based on the, quote, scanty review this court gives matters on its shadow docket. In another, we were criticized for ruling on a stay application while, quote, barely bothering to explain our conclusion, a disposition that was labeled as emblematic of too much of this court's shadow docket decision making, which every day becomes unreasoned. And those cases that he's citing in the opinion are citing Justice Kagan, an appointee of the Obama administration. And Justice Elena Kagan has said the Supreme Court has made a lot of these rulings without full oral argument that have actually changed the status quo in this shadow docket outside of their granting certiorari. So here, Justice Alito is trying to say, look, Justice Kagan, you said that the use of the shadow docket is bad, and now you're using the shadow docket to block this district court's order. But fundamentally, Alito's making a big mistake here, and he's doing it intentionally to be disingenuous, which is that what Justice Elena Kagan was upset about is the Supreme Court using the shadow docket to disrupt the status quo. And what the Supreme Court did here in the 7-2 decision was to not disrupt the status quo. What Judge Kaczmarek did was disrupt a status quo that's existed since 2000 with the approval of mifepristone. And so here, what the Supreme Court's saying is, look, let this go through an appeal process, but we're preserving the status quo of the FDA approval from 2000. So I could read for you the rest of what Alito said, but it's all a bunch of BS, and it just shows you what an extremist he was. But to be fair, he didn't impose his own view on it when the emergency application was sent to him. To be fair to him, he referred it to the full court, and the full court made a ruling that he disagreed with. So I think it's fair to say, at least, that that process that he went through, he could have gone through it in a more corrupt way than he did to get the end that ultimately he wanted, and he didn't go through that path, though. So that's where we are now, and the short of it is mifepristone is no longer going to be, banned, at least for the short term. Mifepristone is allowed to be sold wherever it's being sold before, and its full approvals by the FDA have not been overturned. It will go through an appeal process now with the Fifth Circuit that will get to take full briefing and ultimately make a ruling based on the lower court Judge Kaczmarek's ruling, which would have completely banned mifepristone. So this is a good ruling, somewhat of a surprise by the Supreme Court, but I think when you see my analysis there, you see how they came out with that result. Thanks for watching. I'm Ben Meiselas. Hit subscribe. We're on our way to 1.5 million subscribers thanks to your support. So please hit subscribe. Also check us out at patreon.com/MeidasTouch, patreon.com/MeidasTouch. And wherever you get your audio podcasts, subscribe on audio as well. Thanks for watching. Hit subscribe. Help us get to 1.5 million. Have a great day.
Love this video? Then you'll love the MeidasTouch podcast. Listen as my brothers and I break down the latest news and chat with top political leaders on the fastest growing pro-democracy podcast in the world. New episodes drop every Tuesday and Friday. Add the MeidasTouch podcast right now wherever you listen to your podcasts.